compelling circumstances EAD. There's a lot of talk about this new guidance that USCIS have published. We're going to break it down for you. We're going to answer the question, is it the only option you have, or do you have better options? From the law firm of Sam Shihab and Associates, I'm Sam Shihab. We practice immigration law in the U.S. and throughout the world. Our website is immigrationvisaattorney.com, and with me,
Brian Burke. You know, it's my website too, immigrationvisaattorney.com. There's some beautiful pictures of us, some fashionable photos up there, which you'll enjoy seeing. We have all sorts of good blogs there as well on interesting topics, and you occasionally see some fun YouTube videos. But Sam, let's get to it. Let's get to this presentation in just a minute.
All right. Again, my name is Sam Shihab. With me is my partner, Brian Burke. We're from the law firm of Sam Shihab and Associates. We practice immigration law in the U.S. and throughout the world. We also do family immigration. We're going to be probably doing some family immigration YouTube releases soon. A lot of people are asking us to do them, so we might do that as well. But today it is about employment immigration law. It's about compelling circumstances. USCIS, Brian, released on 6/14 a policy update.
Yeah, what they do periodically is they want to clarify something. They update their policy handbook with some new language. And the compelling circumstances EAD is something that's been around since January 2017. And it's not something that gets used a whole lot, but basically the change in policy as expressed by USCIS in their policy handbook kind of makes it more attractive, which is something we're going to talk about why tonight. But we'll also talk about, maybe why it's not as attractive and what other options you have, in terms of if you find yourself in a spot where, oh boy, my immigration status has gone up in smoke.
So let's simplify this at the beginning so people understand what is compelling circumstances EAD. When was that law introduced?
Yeah, so there's a regulation came in effect in January 2017 that introduced this new type of EAD.
This is the last thing the Obama administration did as they were. This is
the same time where we got clear rules on H-1B recapture, the 60-day grace period, all sorts of good things in there, and this was buried in along that as well.
And for the last 2017 to now 6 years, compelling circumstances has been discussed on and off, but has not taken center stage.
Yeah, because, my impression of it was that there's some downsides to it, and the threshold to get it was really kind of the old version of the policy handbook. I guess there wasn't a lot of detail, and the threshold to get it seemed pretty darn high, that you had to have some pretty extreme circumstances to get that compelling circumstances EAD.
But let's quickly, maybe we can put that on the screen, on the compelling circumstances EAD, and so people understand what are the requirements for compelling circumstances EAD. And the first one is you must have an approved I-140 in the EB1, EB2, or EB3 category with a priority date that is not current. The second requirement, that you must have had a valid E3, H-1B, O visa or L visa status on filing date of that compelling circumstances.
So you must plan for this before you fall out of status. Essentially, this is to cover your butt after you fall out of status, meaning you have to do it while you're still in status.
Now, does the 60-day grace period apply, Brian, to answer that specific question?
The 60-day grace period will very much clearly apply. However, one must remember that the 60-day grace period for H-1Bs, for example, cannot extend beyond your I-94 validity. So it doesn't give you, H-1B 60-day grace period can never give you more I-94 time.
The third requirement is that you have not filed for an adjustment of status yet. So you don't have a pending adjustment of status. If you have a pending adjustment of status, the compelling circumstances EAD is not for you by law. And you have not been convicted with a felony or 2 or more misdemeanors. So no significant criminal background. If you have it, it may not apply to you. And then lastly, you must demonstrate compelling circumstances, which we're going to discuss here in a minute, that justify issuance of the employment authorization. A lot of requirements.
Yeah, and for me, all those, the first 4 of them are given. But that last one, the compelling circumstances, it's a subjective standard, and honestly, my take on USCIS when it comes to subjective standards is that, you better have a really darn good reason, and they're not gonna take, well, you just better have a darn good reason. So
the next thing that people I think want to know about right out of the box is, what did the June 14th change do? What happened that everybody's talking about it? If this was a 2017 law, what happened last week, Brian?
Well, I guess you want to go to the big block of text that really kind of underline for me what they're willing to accept, because
So they provided clarification.
Yeah, they gave one really great example, which kind of makes our collective jaw drop in that it says, if that's a compelling circumstance, a lot of people become eligible for compelling circumstances EAD.
So would you say that that was a significant broadening of the circumstances within which it can be compelling to approve a case?
Yes.
Okay, excellent. So you want to dive into that language?
I'm gonna let it wash all over, to use the liquid metaphor, all of our audience by putting it up on the screen here.
Yep.
And this is right verbatim from the USCIS policy handbook as it is. So it says here, as an example for compelling circumstances, a principal applicant with an approved immigrant visa petition in an oversubscribed visa category or chargeability area, so that means somebody who has a backlog priority date, who has lived in the United States for a considerable period of time and has has school-age children and a mortgage, may face compelling circumstances if, due to job loss, the family may otherwise be forced to sell their home for a loss, pull the children out of school, and relocate to their home country. And here's the kicker. Note that not all of these elements, lengthy time in the United States, mortgage, and school-age children, are necessary for a case-by-case finding of compelling circumstances based upon a substantial harm to the applicant. For me, that is huge. Now, I have considered generally these compelling circumstances EADs to be sort of pretty rare cases in my mind, and mainly because the threshold seemed high. But I've been thinking back about the couple of times I had somebody who maybe really needed one of these things, and they met that requirement for sure. Somebody had been in the United States for a long time with some school-age kids, and I think that's really signals that if that's the standard they consider compelling circumstances, like I said, a lot of people out there are probably eligible for one of those EADs.
So you've been here for a while. You got family. You have a ties to the U.S. and something comes up in which you're not able to extend your HLEO visa, then you could qualify for an employment authorization document that allow you to stay in the U.S. legally and work.
Yeah.
Any job.
I mean, and that scenario is just so pliable in my hands. Okay, I don't own a house, but I own 2 cars, and I have to sell those immediately. I'm going to take a loss on those. I have, any number of investments in I don't know, I'd make the argument based upon, social circles, that's sort of thing. It's really huge.
So considerable period of time, one option.
Yeah.
School-age children, second option. Mortgage, third option. And causing substantial harm, another option. You have all those. Yeah. You have a slam dunk.
Yeah. I mean, I like I said, there's so many people who can meet this. People who are in the United States for a long time. There's a good chance they're going to have school-age children. Maybe not everybody commits to buying a house before they have like a green card, but again, I foresee being able to swap something out. Like I have 2 cars. I have a community that I'm involved in, a church or something like that, where I'm an important member. And plus, they say you don't even require all those circumstances from the example. It seems like it's really, really pliable, and you're able to make an argument for it. And if I were writing one of these cases right now, I'd be just arguing exactly to this example, because it's so close to so many people's lives, generally speaking. And
USCIS has given us other potential compelling circumstances that we can use.
Yeah, put up the of running list here on the screen here.
Yep.
Oops, wrong button. There we are. So there's serious illness or disability. So the example they give in the policy handbook is, you have to move elsewhere in the United States to take care of a family member, like their health matters. But you don't have employment authorization. Whatever employment authorization you have is incompatible with going to work in that region. There you go. employer dispute / retaliation. So this is like like a whistleblower, or you're suing your employer or something like that. That either causes you to be terminated by your employer, or just they even say it doesn't necessarily have to cause termination, but basically to make your employment unsustainable. That's something that they might consider. There's the significant disruption to the employer. Now, you and I spent a little while talking about this scenario. We came up with like one very clear scenario on this one, which was the L1 person running out of time. So, example, you're on an L1B visa. You have an I-140, which is going to be in the EB2 or EB3 category. You're from India or China, which is a backlogged country. And the way L1s work, if you're not familiar, is there's no extension beyond 5 years for L1Bs or 7 years for L1As. You get that amount of time and you're done. So that's somewhere where, and geez, I'm going to lose my job. Something worked. It didn't work out such that I could extend my status or get a green card timely. Here we are, compelling circumstances, EAD.
So employer dispute or retaliation, this is an interesting one in which USCIS wants you to be here if there's an H-1B investigation going on and you're needed, or you believe that you're due some money that you were not paid, or you felt that the employer had retaliated against you by firing you because maybe you were, which is basically there's another visa for retaliation, but obviously they're creating this opportunity for you to stay in the U.S. and continue working as you handle that dispute or that retaliation matter. And how long are these EADs are given for, Brian?
Well, you're looking at 1 year EADs with the possibility of extension for 1 year periods. Yeah.
Until the compelling circumstances are no longer present.
Yeah. So,
but your mortgage, your need for a mortgage, and your children in school, that can be forever.
Yeah, you have 18 years on the kids, and a mortgage lasts longer than 18 years. So there you go, and your time in the United States just gets lengthier. But I guess we got to talk about, Sam, the big downside to the compelling circumstances EAD. That when you file it before you fall out of status, and you have this EAD, and your H-1B, for example, has gone away. Well, you don't have any status at all. You're in a period of authorized stay in the United States. You're allowed to stay. You don't accrue unlawful presence, rather. And you get an EAD, so you're allowed to work. But you don't have H-1B, LO. You have no immigration status whatsoever.
And nor do you have the ability to get back on H-1B or status without.
A direct result of that, yeah.
Without leaving the country.
Leaving the country. So
and coming back in again.
Requirements for getting an employment-based green card are filing for adjustment of status in the United States that you be in status at the time you file. So your path to an adjustment of status is snuffed out.
Well, it's not. It's limited and requires a step. I mean, it's not fatal.
Yeah. You are going to be required to leave the country and come back. Yeah. Same thing for resuming, H-1B status. You're not going to be able to be eligible for a change of status back to H-1B because you don't have any status anymore.
Yes, but you could leave the country, interview at the embassy if you have a job offer for H-1B, and get stamped, and then come back.
Yeah.
On H-1B and continue working on H-1B and pursue your green card, no problem.
Yeah.
There's nothing. About getting on compelling circumstances EAD that prevents that stage from.
Yeah, that is very 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 true. Yes.
All right. So good information on compelling circumstances. Now we want to talk about alternatives to compelling circumstances. What's your first alternative, Brian?
Well, sort of two sides of the same coin. It's hey, maybe I just need a little bit of time. Let's talk about the typical scenario we're sort of thinking of when somebody's going for that compelling circumstances EAD.
Sure.
It's I can't really say this. I realize I can't really say there's a typical circumstances because we just ran through about five different scenarios. But it's changing status. If you only need a status for a little bit of time, changing to a visitor status, right?
So alternative one to compelling circumstance EAD application is filing a request for change of status to a B visa.
Yes.
Yes.
Yes. So let's talk about the problems here. Well, one, if you have an approved I-140 changing to B status could cause a problem because the fact that you have an approved I-140 could suggest to the government that you have immigrant intent, and they could say, "Ooh, you're not compatible with a B visa." Now, thing to point out is if you don't have an I-140 approved and you're ineligible for compelling circumstances EAD, B visa looks a lot better. It's something that we've helped people do in the past to tide them over, for example, while waiting for a labor certification to be approved so you could file an I-140 in the first place.
But in the recent layoff and the problems we've had at the end of 2022 going into 2023, USCIS kind of encouraged the switch to B visa and didn't say that they are going to deny them because somebody's on I-140.
This is very, very true. In fact, they have a nice little encouraging policy for people who are changing to B status. They basically said, hey, if you have a pending B and you file to change back to H-1B, we'll basically approve the H-1B and B together, and basically that'll put you back in valid H-1B status again.
Adjudicate both at the same time.
Yeah, and
because before they weren't doing that.
Yeah, which caused an absolute nightmare because for technical, things we talk about in the office here, like gaps in your I-94 reasons, is why that was a problem. And essentially, I mean, for the cost of filing a B visa, you kind of extend your 60-day grace period. Not exactly, but you extend the amount of time you have to stay in the United States and find a job.
For up to a year.
Yeah, up to a year. Another B visa, time you file a B visa extension, yeah, up to a year.
Why B visa is more attractive than compelling circumstances?
For me, I'm an immigration attorney. I like it when people are in status.
So the application for B visa allows you to maintain status as you look for another job, and you do not have to leave the country like in compelling circumstances application and then come and get stamping and come back. A B visa allows you to continue to stay. Then now compelling circumstance B visa does not give you the EAD.
That is huge. But I mean,
however,
where's your however going with the same?
You can file both at the same time.
Yeah, you could file the compelling circumstances EAD and kind of take the decision to abandon your B transfer if you really need to work. Then again, if you're on an H in this example, Sam, and you really need to work, you file that change of status, you find that job, you find that change of status back to H-1B with premium processing, and you're back in H-1B pretty quick.
But you haven't, but doing both kind of gives you the option to make some decisions. Potentially, if you got the H-1B, you can withdraw the compelling circumstances EAD.
Sure.
We haven't shared the processing time on compelling circumstances EAD that is relevant probably because timing is everything in the scenario. We can put that on the screen.
Well, so let's put this up here. So USCIS, for anybody who's not aware, if you go to their website, they have a page for processing times, and you put in the type of case and where it's being filed, and they'll tell you what the processing time is. What they don't tell you is they don't give you specific processing times for the compelling circumstances EAD category. So basically, this is a survey of the all other EADs category, which is where it would fall then, and all the service center processing times for the all other category of EAD. 14.5
months is a worthless compelling circumstances EAD. Then now it doesn't do anything for me. I mean, even 5 months is too much.
Yeah, and I was looking through the data. The USCIS, if anybody's really bored and likes crunching numbers, go to the USCIS, do a Google search for USCIS statistics. They publish all sorts of interesting data on their everything. And I was going through the data of the last 6 years of how they process these compelling circumstances EADs. The data I saw kind of suggests that these cases are sometimes left pending for a long time, like more than a year. So I am inclined to think that maybe it's on the higher side of this. However, one can't help but notice that there's a shiny new policy put out there that's sort of shining the light on the compelling circumstances EAD.
So this is historical data. It doesn't mean going forward is going to be the same. We may hopefully see a different scenario.
I mean, it sounds like they're opening the door and saying, "Hey, file some compelling circumstances EADs." I would really hate it if the door they've opened leads to a really, really long, painful hallway that you have to walk down to get that EAD in your hand.
Yeah, and obviously the history of approval is not very encouraging, Brian.
Yeah, this is my sort of quick and dirty numbers of approval rate of compelling circumstances EAD since 2017, which is
before USCIS came out with the policy. So we're hoping that there's a change in the attitude, but with a 70% denial rate, it's a dismal compelling circumstances results.
Yeah.
I mean, only 30% are getting approved. 1 out of 3, approximately 1 out of 4 getting approved. 2 or 3 out of 4 are getting denied.
Yeah, these numbers might be a little bit skewed by virtue of the fact that this doesn't, those 2,800 and 2,035. There's still outstanding cases, but it seems like there's a very high rate of denial of these compelling circumstances EAD historically.
Before, yeah. So we're hoping this is changing.
I mean, it's pretty rare that somebody has come up that I thought you might be a good candidate, and the way the policy read previously and those numbers tend to confirm it that hey. Wow, those compelling circumstances EADs are not really a slam dunk.
Right.
Yeah.
But things can change. Maybe this is a change. Clearly, USCIS is trying to change things.
The bottom line is if you're out of options and this is the option you have, it's the option you go with, right?
And also, it kind of supports trying to hedge and file maybe a change of status, B visa change of status, along with the compelling circumstances EAD, therefore allowing yourself with more options. Now, on the front of additional options.
Yes.
What else can we look at if somebody finds themselves in a situation where they need to get in status or do something to stay in the U.S.?
It's the change to F1 status, F1 student status. It has some downsides. You have to pay tuition. That stinks. But there's some potential upsides. There are some schools that allow you to do day one CPT programs that can have you working on F1 status immediately, which is nice for people. That's attractive to people. And it used to be that I would tell people changing to F1 status in the United States is just the worst because the processing times are absolutely brutal. However, effective, I believe it's the 26th of this month, everybody filing for a change of status to F1 in the United States is eligible for premium processing for the cost. Again, a cost comes up of $1,750. And that gets you a decision in 30 calendar days, which is not exactly premium for me, suggests fast. I don't consider that particularly fast, but I'll take it.
Well, I mean, so the policy is that anybody changing status to F1, F2. So if you're doing an F1 for yourself and F2 for your child and your spouse, you have to pay $1,750 3 times?
No, I believe you can. Well, I mean, everybody gets included in the same application because there's the I-539.
And I wouldn't do the F2 and the family and premium processing if I have to pay extra anyways.
But in most circumstances, though, the family members are able to be included, as I recall, on
this application.
On the I-539.
But premium processing is wonderful because, but why would you file an F1 if you find an employer because you can file for an H-1?
Yeah, well, I mean, I almost brought that up earlier, but bottom line is there's a lot of employers that won't touch an H-1B visa with a 10-foot pole. They'll say H-1B visa no, but if you have unlimited work authorization like an EAD, compelling circumstances EAD, or even
an F1 EAD on a CPT,
or F1 CPT,
maybe. Yeah. So there are options. I mean, what you're trying to say is there are options and there are multiple options and you can pursue all of them or one of them depending on your need and the circumstances as you face with the dilemma of not having a job.
Yeah. I mean, when I talk to people about these things, and I just literally had a guy talk to a guy about a pretty similar scenario last week. I guess my instincts always favor, staying in status if possible, because when I talk to people, it's even I understand that I could get back on H-1B status, for example, if I traveled, but that's really stressful and painful because one, I don't know whether I'm going to, first of all, getting an appointment for a visa stamping. Tell us in the comments how bad it is to get a stamping in India right now. I know it's gotten a little bit better, and then there's the fact that I don't know if I'm going to get that visa approved. You know, there's one thing. It's one thing to get the appointment, and all it takes is the 221G, and I'm stuck, you know, for a long time not coming back on an H-1B visa. And in compelling circumstances, EAD, it's not good for travel. You know, it just allows you to stay here and work, not, you know, travel around. So yeah.
Which is it. I mean, it's nice option, but it is not ideal.
Yeah, I mean, I've been aware of this. You know, when those January 2017 regulations came out, we all read over them and said, "Oh, look at all these, you know,
options,
neat things." And I have probably encountered, you know, and I talk to a lot of people about I'm running out of time scenarios. So we talk about that all the time. It's something that people come to us and say, "Hey, I need some other ideas. Can you, you know, my employer has left me in situation X where I can't extend my H-1B. Can you give me?" And it's pretty darn rare that the compelling circumstances EAD is the option. The one scenario I can think of is a gentleman who was here on L1A visa. He was out of time. His employer had just gotten an I-140 approval for him in the EB1 category, but he was from India and it was backlogged. And what they told him is, okay, your whole division in the company is going up in smoke. And we're closing it all down. We're not gonna be able to file a green card when your priority date's current, and we're gonna be shutting down your division in the company. And this person had, it turned out this person had been on an H-1B visa before and had time he could capture with that. And well, there you go. That's why he didn't do the compelling circumstances EAD, because there were
other
options out there. Yeah.
And a lot of people will have other options, but this is obviously gives people comfort that there is something else if all else fails.
Yeah, it is nice to have a safety net, because one of the stressful parts about any sort of immigration denial is you know, you have to pick up and, you know, leave the United States. Yeah, it's stressful. Yeah.
Yep. So that's compelling circumstances EAD. I hope this was helpful. When we come back, we're going to go ahead and answer all your questions. All right. Okay, so this is the time when we answer your questions. Just remember, we don't know enough about your case for you to make decisions on anything we tell you today, but it gives you some background to help you kind of think a little bit and
understand.
Perhaps seek an attorney of your choice to help you with your immigration case. So without further delay, let's begin with question number 1.
Yeah, from My Muziki Love. Do medical conditions qualify for EAD? My husband had a heart attack last year. As a primary applicant, it affects our family. He has had an approved EB2 I-140 with July 2016 as priority date. Better now, job unaffected. So, you know, somebody needing care, you know, if I was thinking about a compelling circumstances EAD, especially based upon the updates to the handbook, I'd say, you know, if this person's getting medical care in the United States, great. You know, and there would be a major disruption to go and continue that in another country. However, the positive bit on the end of this is better now, job unaffected. You know,
which is great news.
The need for compelling circumstances EAD is gone, really. And you know, I'm going to guess if EB2 I-140 at the priority date of July 2016. That you know that your husband has an approved I-140, of course, and thereby you're eligible for H-4 EAD. And
I'm going to add a fact.
Yeah.
Change the fact a little bit.
Okay, I like a challenge.
Make the question a little bit more interesting. But it could be that the advice of doctor that he should stop working for a while, do a recovery or something. If you present this kind of information, now you have
a scenario where he can't maintain his status, presumably. I'm going to presume H-1B because he can't work.
He should not work.
Yeah, he should not work, and then suddenly, well, he's eligible for that EAD.
And the spouse is eligible.
Yeah,
for
the whole
EAD.
family's eligible for the going to be eligible for the EADs. Yeah,
which is a good scenario.
Yeah.
All right. Good time forever.
Good time for.
I love the name.
Indeedy.
Yeah. I have submitted a supplement 485J to request a transfer of the underlying basis from EB2 to EB3. And this was submitted back in February 2023, and still to date, my 485 application is not approved. Okay, well, good time forever.
Well, there's more. There's definitely
Need
more.
a little bit more information, which he may have provided, which is my priority is 2012, February 2012. Recently received a letter saying that your I-45 interview is complete. However, priority date is not current at this time. So we all know it retrogressed, and it was from, was it EB2 to EB3, Brian?
Yeah, I think he was moving to EB3. So I think I have an answer to this, and I'm assuming everything here is factually has it done. Is there anything else to be done next? This is my priority is current until June end. Oh, till June end. That's rough. Look like they're not activated my downgrade request from EB2 to EB3 as EB3 is current in my case.
Oof.
And you're only current through the end of June. So I'm going to go back to the first part of your question, and something jumped out to me as a guy who's filed a lot of transfer underlying bases. So if you're filing a transfer underlying basis, USCIS for their past policy statement, said yes, give us a supplement J along with that, right? I ponder whether or not this individual has actually given an in-writing request to transfer the basis, because a supplement J is I would say probably not enough. If I wanted to do a transfer to underlying basis that complies with USCIS policy, I would want to give them a request in writing that verbatim says, I want to transfer my basis from my existing EB2 I-140 to my EB3 I-140, because the policy.
So you're suggesting that may be missing.
However, occasionally we've gotten like literal calls from USCIS officers saying, "Hey, which one of these I-140s do you want us to use for this adjustment of status?" So maybe that's not what it is. So that's my paranoid version.
There's not much you can do in 10 days.
Yeah, I fully agree with that.
The truth of the matter is, if there's no movement now, absent.
I agree with you. There's not much what you could do in 10 days. What could you do in 10 days, Sam, if you wanted to rattle some cages?
You're going to go through the political route.
That's where my mind goes.
You contact your congressman, and you send them a big bouquet of flowers to their office, and then you tell them, "I hope you like my flowers. I have a need, desperate need. Can you help me out?" Yeah, it can make a difference.
Yeah, that's the only way I foresee any possible, and I guess slim, very slim.
And I don't know what state you're in, but I'm hoping you are with a congressman who is immigration friendly, because some of them are in certain states. Not only are they not immigration friendly, they don't even entertain these type of inquiry in certain states. But if you are in states that's immigration friendly with a congressman who is pro-immigration, you might get lucky. Yeah, very slim chance. Good time forever. I wish you the best.
Good luck forever.
With that one. Yeah. Sky limit, Brian.
So we should also do a session about EB5 as an alternative to H-1B. So EB5 is fun, because if you can make it work, it goes from you can if you file in the right category, for example, filing an adjustment with a current priority date immediately, pretty cool.
Especially if you are in the employment targeted areas, unemployment targeted areas, or the infrastructure areas that are.
Yeah,
I mean,
now. I'm in the have a visa bulletin in front of me, and India is for EB5 for the rural or high employment areas and infrastructure areas, still current. Meaning you'd be eligible. Day one eligible to file for a green card. Now the big old problem with EB5 is it is a significant investment. It's I believe it's $800,000 and $1,050,000 in the untargeted areas, but you're really looking at the $800,000 investment areas, because that's where the priority dates are still current.
But you can borrow against your assets.
Yeah.
And homes recently have increased in price up to 50-60% sometimes.
That's very true, yeah.
So there's a lot of borrowing capacity there. So it could be a potential. Absolutely. We should consider that sky limit. Thank you for bringing that to our attention.
Yeah. I guess I'd say my last subject on EB5 is, I guess we were talking about, compelling circumstances, EADs, dire situations, You can't put together a really great EB5 application, overnight, I guess.
Yeah, but you get 60-day grace period. There's
That's-
plenty of time to put it together, assuming all the pieces fall in place.
Yeah, that's true. Yeah,
I mean, there's a lot of work to
Yeah.
put one together in 60 days, but it's not impossible.
yeah. I've done one before. Yeah. From Bargov. Applied change of status F1 to H4, H4 EAD with future start date. If USCIS makes a mistake with the start date and only approves H4, can I ask USCIS to correct it, and can I terminate my F1 status because of the USCIS mistake? I'm having trouble wrapping my head around this one.
No, I think what's happening here is the dilemma of requesting a future change of status. So when you file an I-539, there's no date in the form that says when would you like this I-539 date to be effective.
I thought they have that on the current version of the form. Let's see.
It could be. Well, if it does, because the older version did not have it.
Yeah, you used to have to like sort of scribble it in manually. But for those who can't tell, I'm looking up the form right now.
Yeah.
New status and effective change of date. There it is.
Okay.
Yeah.
So they have added that in the most recent version because the old version didn't have that.
Yeah.
So his question, then I'm modifying my explanation.
Yeah.
His question is, if they make a mistake and they don't honor the date, can he request a correction? Because he does not want the change of status to be effective now. He wants it 3-4 months in the future.
I see what you're saying. Yeah.
And the answer is yes, you can, because the I-539 form clearly indicates a date after which you want to be in status, not before that date.
Yeah.
The practical challenge is to get them to do their job, because it is very difficult to get USCIS to correct their errors.
Yeah, if they admit they made a typo, they'll usually correct it. Okay, like in a month, maybe. If you're lucky, you'll get a new approval notice. But I mean, I've submitted clear USCIS errors, and their response is, nah, even though it's clearly their error. And just that sort of fight, can drag on for months with USCIS.
Yeah, and that's where the frustration is.
Yeah.
But yes, you're right. In theory, in practicality, if they make a mistake, you're not in a good spot. All right, next one, Brian.
So,
CEO Sonic Solution. I want to start my own business. How do I start? I am on EAD. Whom do I contact first? Excellent question.
Yeah.
Excellent question. First of all, we do, and many other law firms do, offer a service by which we help companies, individuals make that transition.
Sometimes it's a part of the immigration process for an E2 visa or starting up an L1 subsidiary.
Or individual. We've helped a lot of people. So if you, but to answer the question, what is my sequence? I think you begin by you have to first, before you do any steps, you have to understand it. Because if you don't understand it, it's not a cookbook. It's not like baking a cake where you follow the steps without knowing why this before this and that after this. So you need to understand. Understanding is very important. You need to create a company. What are the limitations? What's AC21 allows you to do? What AC21 doesn't allow you to do? And what position you want to be in? So when it comes to adjustment of status, you can adjust without a problem.
I'm not reading that as an immigration. You're thinking about port to self-employment, right?
I think so.
Maybe.
EAD?
Yeah, he has an EAD. I guess it's something you can do. I was kind of reading it as a nuts and bolts of, hey, I've never started a company before. How do I?
But he's on EAD. I'm assuming there's a green card pending.
Yeah. Okay. Well, maybe it is an AC21 portability scenario. I thought it was more of a nuts and bolts, like, hey, how does one start a business?
And that's why you should never rely on our answers, because we don't know enough about your question. This is a great example. Go ahead and answer the simpler one, because I've given my answer.
I mean, the basic answer is, in the United States, every state has a Secretary of State, and those are responsible for the creation of businesses. Now, and there's lots of attorneys just like us who will basically help you start a new business. And, I guess, especially if you're pursuing like an AC21 portability scenario based upon it, an attorney's probably a good idea, because they'll make sure it's done right and give you all sorts of good corporate documents to basically make everything a little bit more cleaner, a little bit more official. They'll probably set you up with some share certificates, some, articles, an operating agreement for the company, that sort of thing, to make it a little bit more official and cleaner.
Oftentimes, as a limited liability company, because you're not a U.S. citizen, that's the most preferred option of a corporate structure. You need to understand what a limited liability company does. So there's a lot of reading and understanding on your part you have to do.
Yeah, for sure.
And then obviously, I mean, there's a lot to learn, right?
Yeah.
So I think engaging an attorney that can help you with these steps is a smart thing, because there's going to be 25 questions that you should ask, and there's another 25 questions that you haven't thought about that you should ask to go through the process. TS, Brian.
On my recent entry to the USA, stamp and my passport and I-94 do not match for dates. Ooh, a classic question, one I haven't heard for a while. Stamp says same expiry as I-797, but online I-94 is 2 months short of that date. Should I contact a field office?
Yeah, of course you should contact the field office and fix it. And by the way, congratulations for discovering it.
Yeah.
Because it is painful, especially that the I-94 online is shorter. That's almost the classic setup.
Yeah.
Because you assume everything's okay.
Well, the setup is to kind of trick somebody into falling out of status by saying, my I-797 says I'm good until July, but it turns out I'm only good until May because the I-94. Well, the I-94 controls, right?
Yeah, and check your passport, by the way. Expiration of your passport, that could may have driven that earlier date. Be that as it may, if your passport is valid for more than 6 months beyond the I-94 date and beyond your I-797 date, 100% you need to contact the field office and get it corrected.
Well, yeah. So, if you contact Customs and Border Protection, they're surprisingly they're sometimes able to make corrections that I'm surprised about. But there are sometimes more or less legitimate reasons why they limit an I-94. Like, for example, they'll limit it to the validity date of your passport,
Right.
for example. And that's governed by treaty, as I recall, that they can't issue you an I-94 that is beyond your passport. Well, Customs can't. Apparently, USCIS thinks they can because they have no problem doing that.
Yep.
Yeah.
CEO Sonic Solutions. I have an I-485 adjustment of status pending. EB2 category. I want to be a software architect at the same time I want to run the company.
Well, feather in your cap, Sam. You're talking about. I guess you was talking about an AC-21 kind of scenario.
Good. Well, it's good. I'm glad he clarified it. Thank you. And then there's also another follow-up question on the next slide. Might as well take that.
This is another follow-up question. Should I be generating revenue as soon as I start my business, because that's practically not possible and shouldn't impact AC-21 portability? Well, I see an issue. I don't know, a concern regarding AC-21 portability here. I want to be a software architect, and at the same time, I want to run the company.
Yeah.
Right.
Yeah. So there's a lot there. So we try to we try to maybe get your spouse to be the CEO, and because we want you to be working full time in a job that matches the labor certification. We don't want you to divert your time to do things outside of that, if possible.
Yeah. The requirement being that your AC-21 portability must be to a same or similar occupation, and if you're running the company, you're devoting time to that, and suddenly your occupation doesn't look, presumably if you have an IT-related...
But as long as he's putting in 40 hours, he can do additional time doing other things.
That's a good point. Yeah, that's a very good point, yeah.
But it is not it's not the end of the world, but if we can separate them, that will make your job so much easier.
Yeah.
The presentation is so much more crisp and clean. So you can do that if possible. And then you need to set up the limited liability company. You need to set up beyond payroll. As far as income, Brian, if there's savings and there is an investment in the limit, let's assume he put in a $50,000 in the limit. His savings.
Invest money in the company.
But you must receive paychecks from the company on day one. Yeah. You don't have to generate revenue, but you must receive paychecks from the company on day one. Therefore, you have to put money in the company and then pay yourself. And hopefully within a few months, you're able to start generating revenue such that by the end of the year, at least you are on the positive side of the equation, not on the negative side of the equation. And then you will be in good shape. So I wouldn't jump in doing something like this unless I have some promise of work on day one or close to day one, so you can do it contemporaneous with the opportunity, so you don't run too much negative in the income. That would be my advice.
Yeah, I think that's
Yeah.
fair. Yeah.
Yeah.
So and that takes care of the revenue.
So the passport is valid beyond I-797 expiry date, and I'm hoping for 6 months.
Yeah, sometimes they line it up with the visa expiration date, and that's that's not something they should be doing. But sometimes they do that. That's something where I'd say that's wrong, guys. Fix it.
The stamp,
yeah,
the visa stamp on the
visa
passport,
stamping.
which is an error.
Yeah.
That could be where it's at. But that's fixable still.
Yeah, if it's just a short Google, find a secondary Customs and Border Protection secondary inspection site, and people answer the phone, and they're surprisingly helpful.
Yes. So, Barga, I've got a question for you.
Yeah, I think we may have answered this one. So, if USCIS makes a mistake with the F1 to H4 COS start date, can I continue to work on F1 STEM, OPT, EAD, and reach out to USCIS to correct the start date mistake?
So the question here is, can I continue
yeah.
working? Well, that question was there. We may have neglected to answer it. So that's a tough one because you'll be taking a risk working when you no longer have the.
That when you are on H4 status, that F1 OPT EAD is not a valid EAD. It is incompatible with your status, with your H4 status that USCIS has given you. Now, and I guess that's kind of the conservative take on that, which is a pretty fair one.
Now, defensible. It can be defensible.
Yeah.
A little bit because you clearly requested it and they made an error, and then now you're committed to fixing it because if you continue working, you want to make sure you're legitimate. Yeah,
the alternative take is that's not what I requested, and basically, there's a fundamental question. Just because USCIS approves something, does that mean I have to take that status? My mind could have changed, and that's kind of a great wishy-washy, wavy gravy area in the world of immigration. Does USCIS say that your status has changed? Is that necessarily a requirement?
Yeah,
and they've been understanding on this issue before with some interesting results. Yeah.
Yes. So CO Sonic Solutions has a follow-up question.
I love a good follow-up.
And he likes to call himself the chief architect of the company, which matches my AC21 profile. And at the same time, I can pursue business. Yes, absolutely. So if your AC21, meaning the labor certification perm, was a chief architect of some sort, and now you're called the chief architect of your company, that's perfectly okay. However, be aware that what USCIS is more interested in is the job description and the job duties and responsibility, more so than the title. The titles are not unimportant, double negative. They are important, but they are less important than the job description that you have.
No, that's the last one we have for the.
Well, we thank you guys. I know today is an off day.
It's a holiday. I presume everybody's out there having a nice.
Absolutely. So I'm glad you guys showed up and talked to us. We will be talking to you next week, 6 o'clock Eastern time, and perhaps EB5.
We haven't talked about EB5 for a long
or something.
Time.
So we will definitely bring a topic of interest and answer your questions. Until next week, you guys have a wonderful day. Have a wonderful week.
Wonderful day too.